Awesome. Okay, so while everyone is joining, we'll just go over a few housekeeping for today's presentation. Just if you could just keep your microphone muted so that way we don't have any background noise. If you have any questions, feel free to put it in the chat and we can address it as we go along. This presentation is recorded, so once we get that up, we can distribute it as well. If you signed up before about 11 o'clock today, I did send the presentation to everybody. I will be sending it again to everyone along with other handouts, so look forward to that. Just to keep it fun, we'll have some polls throughout the presentation. And yeah, that's about it for housekeeping. So I'm sure everyone has been bombarded with this information, but we can't tell enough that we have recently changed our name from NASA Suffolk Law Services to Legal Services of Long Island to represent more about who we are and what we do. So we do have a new website, legalservicesli.org. Everything else is the same. Our emails will be changing soon. But everything, of course, is always redirected. So even if you email our old email address, once we change, it'll still come to us. So don't worry about that. So if you're unfamiliar with our organization, we are the largest legal services provider on Long Island. We handle over 6,000 cases every year. We provide free representation to eligible Long Island residents. That could include full direct representation, consultations, either via the phone or in person, brief service, or referrals to other agencies. We have 3 different offices, one in Nassau County and Hempstead, one in Islandia, and one in Riverhead. Our case handling staff include attorneys, paralegals, and also we have social workers on staff as well who help out if someone has something outside of the legal aspect of their whatever issue they're going through. And we do have partnerships with community agencies such as Brighter Tomorrows or Empire Justice. So we work with lots of other agencies. And these are our different locations. We do accept walk-ins. It is preferred, though, that clients call our phone number to be screened for eligibility to see if it's something we can handle and if they're eligible. Riverhead is really for folks who are east of 112. We have about 20 different programs, including housing, eviction prevention, foreclosure, other areas such as consumer debt, which is, like I said, I supervise the consumer debt unit in Suffolk County. We have a new program, the Education Debt Consumer Advocacy Project, which helps out with folks who have student loan debt or other student-related debt. We have our Veterans Rights Project, our public benefits, adult care facility. All of the descriptions of every unit is on our website. We also have our family law related projects in Suffolk County, including domestic violence, child support defense, and our disability health related units, such as our mental health unit and our education disability rights project. And brought to you today, this presentation is brought to you by the Legal Support Center for Advocates, which is one of our units here. A specific unit made up of myself, Hannah Fitzpatrick. Say hi, Hannah, if you want to unmute yourself.
Hi.
So she's our paralegal here with the Legal Support Center for Advocates. And then we have Kathy Lucidi, who I'm sure many of you are familiar with. She's on vacation. So she is not here today, but she will be back. Don't worry. But we are here for advocates, whether it be social workers or folks who maybe volunteer for a church or work for an elected official or work for a government agency or other attorneys who have questions about a specific, whether or not we are able to assist a client with a specific need that maybe their client has, or if they just have a general legal question and need some legal information, or they need a referral, we can get you that information. So we are here to help you for advocates. And just as a reminder, this special support center is for advocates only. We do not speak to clients because we don't handle cases. So any clients do need to go to our front desk, our receptionist, so that way they can be screened for eligibility. But other things that we do is I send out advocacy tips every month for folks. We do host other community trainings. We have a legal resource fair coming up next week that we're putting together at the Brentwood Library, where we'll be doing Know Your Rights presentations for the local community, and other things. So follow us. Okay, so we've come to our first poll. So I'm going to put it up here. The first two questions are going to be, what type of advocate are you, and have you ever called LSCA? So let me bring that up just so we can get an idea of who we have with us today. So quickly, what type of advocate are you? So if you could just take a moment to just fill out the choice, I'd be really appreciate it. Okay, so looks like we almost have full participation. Okay, so I'm going to end the poll and share the results. So it looks like we have a bunch of attorneys on today and some nonprofit employees, government agency, church volunteer, social worker. So thanks so much for joining us today. Next question. Okay, have you ever called LSCA? So if you just answer that really quick. Okay, almost there. We have 68% participating. Okay, I'll give another 10 seconds. Okay, so I'm going to end the poll. Thanks for answering. And we have one person who has Kathy Lucidi on speed dial. So that's amazing. Some of you have already been in contact with us, so that's great too. And then a lot of you, actually, this is the first time you're learning about our program. So thanks so much for learning about it, and feel free to use it in the future. Okay, so next up, we have our website. So definitely check out our website. Like I said before, we have information on all of our programs. You can sign up for our email, our legal lessons, learn more about trainings, access past trainings. We have self-help resource on there. Some that can't talk. Self-help resources on there and other different things. So definitely check it out. And then, of course, today, just a little note, I'm only giving legal information today. I'm not giving legal advice. So, of course, we try to keep our information that we provide up to date as much as possible. Legal advice is when it's actually depends upon the specific facts of each situation. So that is more of like a one-on-one conversation. So that is not something that we're giving today. And it's, of course, you should always, if you or a client are dealing with some kind of medical debt, it's always best to seek the advice of competent legal counsel. Okay, so our agenda today, we're going to talk about medical bills and how to handle them. What happens if you are in collections? What if you are sued? And what if you have a judgment? Okay, so next poll. There's only a few, so. Okay, where is my polls? Okay, so have you ever received a medical bill? No, I know I can definitely say yes on that one. Okay, so we're 80%, almost there. Okay, a few more seconds. Okay, I'll end the poll. All right, so looks like some of you have received more than a $5,000 medical bill, which I'm sure was shocking. I know that would be, to me, it'd be shocking. Some of them are smaller, more than 50, more than 500, more than 1,500. So yeah, it seems like we've all dealt with getting a medical bill. Okay, so what to do when receiving a medical bill and when you're insured. Now, of course, I've dealt with a lot of clients. They're probably similar to some of your clients. And some of my clients have been very ill and they just have bags and bags full of medical bills and they don't know what to do with them. And that can be very overwhelming. Or sometimes you just get something and you're like, oh, I don't know what to do with this. Or you just ignore it. So, but definitely, the best thing to do is once you get a medical bill, you should definitely review what's called your explanation of benefits. And that is something that you get from your health insurance company. So your health insurance company does, after they receive the bill from the provider, the healthcare provider, and they pay it, they send you an explanation of benefits. And it just kind of details what they paid, what was billed, what was paid, and what your responsibility is. So that's why it's important to take a look at your EOB to see if what you're being billed matches up with what your health insurance states that you should be billed. And if you look at that and it does match, that's great. Sometimes you might have co-pays or deductibles, or, typically that's what you would have, co-pays or deductibles or co-insurance. So you just take a look. Now, if you look at it and you're like, you know what, I don't think this is something that I owe, maybe my health insurance company was wrong. Or maybe it doesn't match. You can call your health insurance company, contact your health care provider. The first step I would do is if the provider is billing me for something that doesn't match my EOB, I would call the healthcare provider first to tell them, hey, I don't owe this money. My EOB says this. And typically that's a great way to resolve it. If you have a disagreement over, what if the health insurance didn't bill properly, or they aren't saying your responsibility is correct, like maybe it's preventative care and you shouldn't be billed for that, then you could contact your health insurance, and a lot of times they'll just review it again and then correct it. You should always document conversations. Whenever I do this, I always write everything on the bill, or I have a document somewhere where I'm just writing notes about our conversation. So that way I remember it's fresh in my head. And then, of course, if you can't get it really resolved, it's not really working, but the first step, then you should make appropriate appeals through the health insurance provider. And they always, whenever they send you the EOBs, there's always information on that and how to make your appeal and the timeline as well. So what is balance billing? So balance billing is when let's say you go into the hospital, you see an anesthesiologist, or wherever you go. Your health insurance pays the healthcare provider what the agreed upon payment is. And then what happens is you get a bill between what the healthcare provider billed and what the health insurance paid. So let's say the health insurance company billed for $1,000 and the health insurance company paid $500, but you don't have a copay. But for some reason, the healthcare provider is now billing you the difference, which would be $500. So that's called balance billing. Typically, this happens with out-of-network providers, although it could happen with network providers too. But in the past, and we do have new laws, which I'm going to go over in a minute. But in the past, it was always out-of-network providers who were doing that because they didn't have a contract with the health insurance company. So they would just bill what the difference was. So luckily for us New Yorkers, there's the surprise bill law went into effect in 2015. And so what that says is an out-of-network doctor cannot bill you for whatever the difference is without written consent that you're acknowledging what that cost is going to be. And typically that would apply when an out-of-network provider treats you during your visit with an in-network doctor. So in the past, that would always happen in emergency rooms, or maybe if you went in for surgery. A lot of times if you go into into a hospital, the anesthesiologist is out of network, or maybe the emergency room doctor's out of network. So those were typically the situations when you would be getting the balance bill. But now that is against the law. That should not be happening. I know a lot of times also people would complain to me that their in-network doctor sent whatever blood or whatever tests to an out-of-network lab, so they were getting billed for that. So that shouldn't be happening anymore. Now, the difference is that this is really only applies to folks who have insurance coverage through an employer. It doesn't apply to people who are self-insured. And what I mean by that is typically self-insured is when they get their insurance through their union. So that's a little different, and that actually is covered by federal law, but there are some laws for that type of insurance. But if you do receive a bill, and you are being balance billed, you can send a surprise. First of all, like I said before, I would once again contact your your healthcare provider and your health insurance provider and try to fix it that way. Another way is you could send the surprise bill certification form, which I will send you a copy of after the presentation. If you don't have a resolution, if you're not getting anywhere, you can file a complaint with the New York State Department of Financial Services. Okay, so for the federal law, this is for, like I said, the health insurance companies that are self-funded. This was enacted in January 1st, 2022. So this is for any self-funded insurance that was renewed or issued after January 1st, 2022. So this is very similar to the New York State law, where you can't receive surprise medical bills or be balance billed from an out-of-network provider when you see a provider at a hospital with the hospitals in network or an ambulatory surgical center. Now, this is not retroactive. So like I said, it's only for those issued or renewed after January 1st, 2022. And more information on that, if you want to get into more details, is found on the CMS website. And this is a clickable link if you are looking at a PDF. Okay, so with those type of insurances, if you're being billed, you can submit a payment dispute with the Centers for Medicare and Medicaid Services. But like I said, once again, you should always try and resolve it first with your health insurance provider and with your with the healthcare provider, because sometimes it's just easier to get it done that way and they'll resolve it right away. But you have to watch those timelines also. You could also, if your plan is issued before January 1st, 2022, you can make a request with the New York State Department of Financial Services for an independent dispute resolution to see if you can come up with something. A lot of times, if they are for whatever reason entitled to balance bill, you can always negotiate. There's always room to negotiate. Okay. So what if you end up owing money to a healthcare provider and you cannot afford it? So you should definitely contact the provider to request financial assistance. Hospitals generally always give financial assistance. In fact, they're required to in certain instances. And even if they typically will provide it to anybody who asks. So you just have to send in your income, and then typically they'll give you some kind of low or an affordable payment plan. And always remember that, the health insurance provider isn't paying full. So why should you be paying full? So just remember that you can always negotiate lower and affordable amounts. Now, of course, that's typically with hospitals. Other doctors may not be as willing, but it doesn't hurt to try. So just a few things to remember when you're going through this journey. Even nowadays, if you, let's say you see an out-of-network provider, a lot of times, like I said, those are maybe anesthesiologists, or I see this a lot with bariatric surgeons. Typically, they don't take anybody's insurance, and so they're always out of network. And what I've seen happen quite a bit is your health insurance provider will send you the check if you're the one who is the primary holder on the health insurance account. They'll send you the check, and then you are supposed to know to send it to the doctor. So a lot of times our clients can get confused by that. I've had clients who received multiple checks, had no idea they were supposed to send it to their doctor and just kept it in envelopes because they thought they were copies of checks that were sent to the doctor. I've had clients who received the check and thought it was just free money for them. Or sometimes I've had clients who received a check and said, well, I owe like $50,000 in arrears on my home. I'd rather save my home than pay this. I can figure out this medical bill another time. But just fair warning that those checks should be going to the doctor and you will be sued if you don't pay them. And many times the doctors are not happy and they do not want to settle for anything less than what the health insurance company sent you. So just keep that in mind. I've seen that many times where people just keep the money and don't send it to the doctor, and then they're sued and they have a judgment. So definitely remember that. Always keep receipts when you do send the check to the doctor, because you want to have proof that you did send it to them. Also, Medicaid recipients should almost never receive a bill for medical services. Typically, a Medicaid recipient, if they were going to be paying the doctor directly, they would need a private pay agreement in writing between the doctor and the recipient. So just keep that in mind. I've seen folks who are on Medicaid billed many times. It's also important to remember if you're a Medicaid recipient and you receive a bill, call a doctor right away. Make sure they have your insurance. Very important, because for whatever reason, sometimes hospitals and doctors don't their system gets messed up. I've had to call up my doctor in the past. I had to call them at least 2 or 3 times and say, you have the wrong insurance on file for me. Make sure you have the right insurance, because they had it listed incorrectly. So really important to be proactive and make sure that they have the correct information if you are receiving a bill. Don't just ignore it. If Medicare recipients should contact 1-800-Medicare or their Advantage plan if they receive an unexpected bill. Typically, Medicare recipients, should only be paying their copay, which is typically about 20% of whatever the negotiated rate is. Also, there's a great website called fairhealthconsumer.org, and that's a way to look up what the typical cost is for a procedure in your area. So if you have the procedure code for a certain procedure that you had, you can just put in the procedure code and your zip code, and it'll tell you what the fair and reasonable rate is in that area. So you can make sure that you're being billed properly. Okay, next up. Next poll, have you ever had a lapse in health insurance? And I can definitely say yes to that. So let's get that one up. So if you don't mind just answering that really quick. Okay, another few seconds. Thanks for participating. Okay, so I'll end the poll and share the results. Okay, so about 44% of you have had a lapse in health insurance and 56% of you have not. So that's great. So it's about 50-50. I know myself, when I was in law school, I did not have health insurance because I felt I was young and healthy. Why do I need health insurance? So I think that's typically thoughts of many young people. But it's definitely important to have health insurance. And if you don't have health insurance, there are ways of figuring out the medical bills. But I did have a client once who was young and healthy and got into a ski accident and was disabled after that. So he did not have health insurance. So he had, $50,000 to $100,000 in medical bills that we had to help him out with. So it's definitely important to keep your health insurance up to date, but things do happen and that's okay. We just got to try and figure out how to work through it without doing bankruptcy. if you can avoid it. So what to do when receiving a medical bill and you are not insured? So like we talked about a little bit before, you can apply for charity care or financial assistance if your debt is with the hospital. You do have to apply within a certain time range. Typically, it's 110 days, but some hospitals will extend that further. They do have to give it to patients or provide charity care to patients who are under 300% of the federal poverty level. But I've seen hospitals give it to higher than that percentage. So like I said before, don't be shy, still apply. Repayment agreements cannot require more than 10% of a patient's gross monthly income. The repayment agreements are typically, very easy to navigate and for clients to afford. So please apply for it. You'll most likely get it, even if they're co-pays or co-insurance. Many, many times the hospitals will still apply charity care because there is a fund where they get this money from the state. So still apply. Also, you can apply for Medicaid if you don't currently, if you were eligible within 3 months prior to the injury, you can still apply for that Medicaid and have any debts that you had prior to the application date applied, as long as you were financially eligible. So it doesn't hurt to apply for that. And then of course, you can do that through the New York State of Health or going to your local Department of Social Services. And sometimes the hospitals will help out with that as well. And there are some other organizations on Long Island that help with applying for Medicaid and other health insurance, such as Health and Welfare Council of Long Island or the Nassau Suffolk Hospital Council. And don't forget, many medical providers will reduce their rates for private pay, so it does help to negotiate a lower amount with a payment plan. Of course, always get everything in writing. Very, very important. Everything must be in writing. I remember when I did have that lapse of health insurance, I didn't have dental health either, and I had a terrible infection in my tooth. So luckily, our dentist gave us a cash discount, so that was good because I was in a lot of pain. Okay, what to do if you are in collections? So, a lot of times, once you're in collections, you'll get phone calls, you'll get letters. So if you do get debt collector phone calls, don't give any personal information over the phone and always request something in writing regarding the alleged debt. I remember when I was in my young 20s, my early 20s, I went to an emergency room because I had, something wrong with my eye. And then I moved around quite a bit, so I never got the bill. So then I got a debt collector phone call and they were asking me for my social security number. And I said, I'm not giving my social security number over the phone. Just tell me what this is. And so finally they did tell me what it was. And I said, okay, send me whatever you have in writing and I'll look into it. So I did look into it. I ended up owing the debt, which was fine, but definitely important to not give any personal information to the phone because you don't know who you're talking to. So just a reminder. Response to debt collector letters. You can request a verification of the debts. If a lot of times they don't give much detail in there, like the date of service, they'll just say, oh, you owe this money. And then you're like, well, to who? So always request verification of the debt. That you can dispute the debt. In the past, whenever I've gotten some kind of letter, I'll say like, no, here's a copy of the EOB, take a look at it, and then that resolves the issue. And then you can also tell them to stop writing you and stop calling you. That must be in writing, and they have to honor that. There's a great website called daisydebtapp.org that actually will help you write these stunning letters. So it just drafts it. And I think, I'm not 100% sure, but they might also send it for you if you request, but I would just double check that. But it is a great app to use for your clients or for yourself. I will be sending out some sample dispute letters as well after the presentation. Okay, so with the Fair Debt Collection Practices Act, that's a federal law that regulates all the debt collectors. Now, this is just as a reminder, a debt collector is not the hospital. It's a company that they hire to collect the debt. So if the hospital doesn't, the rules don't apply to the hospital or the healthcare provider. They only apply to the company who's collecting the debts on their behalf. Okay, so just remember that. So they can't be calling you between 9 o'clock and 8 a.m. They can't threaten to tell your employers, your neighbors about the debt. They cannot falsely threaten to take illegal action like arresting you. They can't harass, threaten, embarrass, or intimidate. And you can, in fact, if they are violating some of part of this law, there are attorneys who specialize in this area of law and specialize in suing folks in this area of law. So you could always, if it's really bad, you can definitely contact an attorney and sue them potentially for violations of the law. So just keep that in mind. Okay, so medical debt and credit reports. So the good news is that a lot has changed recently for our credit reports and medical debt. But just some information, you can access your credit reports from all three of the major credit report bureaus, Equifax, Experian, and TransUnion. You can access your reports free once per week. If everyone recalls, before COVID, it was once per year. So now we're at once per week. So that's pretty awesome. I like that. Always go to annualcreditreport.com to access your credit reports, because this is the official place to go to get your credit reports and download them. You can also call, or you can submit a request through the website or print it and submit it to the address that I listed there. So things like Credit Karma or any those other entities that look at your credit score. A lot of times people keep track of that. That's fine and all, but that's not really your full credit report. So that's why it's important. If you feel like there might be something on there, you want to really make sure, download your credit reports from this website. Okay, and then that way you can dispute any errors that you see or any information on there that shouldn't be on there. Okay, so just a quick poll, and I think this is the last one. And this is one just for fun to keep us engaged. In February of 2022, what percentage of New Yorkers had medical debt on their credit reports? So just take your best guess. And then I'll give you the answer. Okay, about 80% of you have participated. So if we get a few more. Okay, so I'm going to end the poll. So most of you guessed 25%. And then another few of you guessed 10%. So actually the answer is 6%. So 6% of New Yorkers, according to the Urban Institute, had medical debt on their credit reports in February 2022, which equates to about 700. Well, I didn't do the math. Someone else did the math. So it was about 740,000 New Yorkers. So medical debt and credit reports. Effective July 2022, paid medical debt is no longer on credit reports. So that is awesome. That's really good, because that was definitely hurting folks' scores. You do have a 1-year grace period to work with insurance or medical providers before the debt is listed on the credit. And then as of April 2023, medical collection debt less than $500 will not be included on credit reports. So this is really, really important. I know of folks who've been applying for mortgages to buy a home, and just because of some medical debt. In fact, the person who this was an emergency room doctor, and he had some medical debt on his credit report that he was, unable to, for whatever reason, had missed or couldn't resolve in time or whatever it was. And it made his interest go up slightly. So maybe for him, it wasn't a big deal. But for others, it could certainly be a huge deal having that interest up a little bit when you're applying for a home. So as a result of this, it removed nearly 70% of collection accounts from the consumer credit file. So that's really great. And there is a proposed rule currently. It hasn't, as far as I can tell, I researched this, but as far as I can tell, hasn't been finalized yet, but there is a proposed rule to prevent most medical debt from appearing on credit reports. And in New York State, as of December 2023, New York does ban hospitals, medical providers, or ambulance services from providing negative information about medical debt to consumer reporting agencies. So that's awesome. So that's why it's important to download your credit report if you did have medical debt on there in the past to see if it's still on there. Now, just something to remember, medical debt does not include medical debt that was charged on a credit card. Okay. So like people use, I think it's like care credit for dental work or for their pets, medical bills at the veterinarian. So that can still be reported to your credit report, to their credit reporting agency. That's not considered medical debt. That's considered credit card debt, even though you're using it for healthcare services. So just keep that in mind that it's not the same thing. Now, if you or a client has a judgment or lien, whether it's medical debt or any kind of debt, that shouldn't be showing up on your credit report. This happened in July 2017, where they basically removed all liens and judgments from credit reports if they were missing certain information like a name, address, or security. But the essential effect was that anyone who had a lien or judgment listed on their credit report no longer has that on there. So just keep that in mind. If you do have a dispute with the credit reporting agency, you can dispute with each individual agency via online and writing or on the phone. And I have some links there for you. You should also be disputing with the medical provider and collection agency who is reporting that incorrect information. If your identity has been stolen, make sure you file a police report, freeze your credit report, do a fraud alert with the credit bureaus, and you can get more information on identitytheft.gov. So over the summer, I think it was, my mother-in-law got a strange phone call from someone who said they were from Medicare and saying something like that there was, something that she had to verify. I forget the whole story, but basically she gave them all of her information over the phone, including her social security, her email. And then she realized about 15 minutes later what she had done, and she called Medicare and they told her, no, we didn't call you. That's not a number that we have. And so when she called me and my husband, I said, you have to use your credit report like right now. So, and I gave her all the steps. So she did that and she hasn't had any problems. So thankfully, but definitely important to, it's obviously sometimes we all get taken advantage of. I know I have in the past, but as soon as you realize it, freeze your credit report. I told her, change your passwords on everything. So really important to make sure that if that does happen, just, follow the steps that are listed. Okay, so what if you are sued? So medical debt actions must be filed in the county where the debtor resides, where the procedure took place, or where the plaintiff resides. As of April 3rd, 2020, medical debt actions have to be filed within 3 years of the date of service. So if you receive services from the hospital or a doctor in 2021, they have to sue you by 2024. Courts have determined, so this is where it gets a little confusing, which is why it's important to have, advice and counsel from a competent attorney. So this hasn't been determined retroactive, but some courts have determined it retroactive. So it's still kind of out in the air whether or not this law was retroactive or not. Meaning, can people still be sued from before 2020, any debts that arose before 2020? So just keep that in mind. If something comes up, it's still important to talk to an attorney about it. Small claims, so that's under $5,000. There's going to be a court date on the notice that served you. And you do have to appear on whatever the court date is, or else a judgment will be entered. So when that does happen, make sure you bring all supporting documents and make all your arguments at the hearing. So, but typically it's always brought in either district court, the Supreme Court, depending on who is suing you and how much it's for. Typically, the Attorney General always sues in the Supreme Court. I've never seen them not sue in the Supreme Court. And the Attorney General is the one who's suing for Stony Brook Hospital or another state hospital. But here on Long Island, that would typically be Stony Brook. So a lot of times when people call, they say, I received this papers, but there's no court date. So for this type of lawsuit, there's not going to be a court date. So just keep that in mind. If you get something that's called it's called a summons and complaint, you'll either someone will come to you and either give it to you in your hand, or you might find it on your door, or maybe if you weren't home, but another family member was home, then they might say, hey, I got this. So there's different timelines depending on how you were given the paperwork. So once again, important to talk to an attorney about that if you can. You would go to the court clerk, whether it's the county clerk for the Supreme Court or at the district courts, the clerk is right there. And you have to file an answer, and then you have to send a copy to the plaintiff's attorneys. And once again, there's not going to be a court date until after the answer is filed. So like I said, you're not going to know what it is until after the answer is filed. Once you file the answer, there could be arbitration that's scheduled that's typically in the district courts, or they could schedule a conference with the judge or a hearing with the judge. Sometimes the attorneys, they'll just file a motion for summary judgment, which means they want a judgment right away. They don't even want to they don't want to go in front of the judge and talk to them about it. If you don't have any defenses, try to get a reduction, like we talked about before, and enter into an affordable payment plan. In the stipulation, you should ask for a grace period. So let's say the date that your payment is due is on the 10th. Typically, there'll be a grace period, like a 10-day grace period. So make sure there's kind of grace period, because if you don't pay it by the grace period, then they can automatically enter a judgment. So keep that in mind. It's really important to stay on top of your payments, because it's really hard to get back into a stipulation with the attorneys if you missed the payments and now a judgment is entered. So some defenses you might have are that you had health insurance during the time alleged. The medical services were provided. I've seen that many, many, many times where the person had health insurance. The health insurance wasn't billed properly. Maybe there was multiple insurances. I had a client once who got into a car accident, and so the car insurance was supposed to be billed, plus her Medicaid, plus the other insurance she had. They just didn't bill everybody. So that was the problem. We figured it out though, thankfully. Maybe you dispute the amount that's claimed. Maybe they're suing you for something that you don't actually owe and you have the EOBs to prove it. You didn't receive the medical services. That certainly can be the case too, especially if you have identity theft. The claim was paid already, so that can be a defense. It was a surprise bill. I've had that happen many times when people are sued and they shouldn't have been, because it was a surprise bill. I already talked about them not being, the insurance not billing properly, or the amount billed is not fair and reasonable. So that's where fairhealthconsumer.org comes into place. You can take a look to see if it's a fair and reasonable amount. Now, what if you have a judgment? There's many, many times when clients come to us and they had no idea that they were sued, it's really not that uncommon. People just have no idea because maybe this process server didn't actually serve them, whether they served them at the wrong house, or I've had process servers who literally don't serve them, that they say that they serve them with court papers and they just haven't. And we have video proof of that happening. So it's not uncommon for someone to have a judgment because they literally never got the documents telling them to go to court. So if you do have a judgment, of course, and you're eligible, please call us so we can see if we can help you out. But judgments, and there are people who just have judgments and there's literally nothing that they can do to get out of it. They can be collected upon for 20 years. And if a payment is made, then they renew for another 20 years. So even if you're at 19 years and 180 days and you make a payment, that judgment can potentially be renewed for another 20 years. So just keep that in mind. If you do receive an information subpoena, very important to respond to them within 7 days of receiving them. There are some very aggressive attorneys out there who, if someone doesn't respond to an information subpoena, they will ask the court to basically compel them to answer. And if they don't do that, then they actually try to get them arrested. I did have a client once who was arrested because she didn't fill out the information subpoena. And of course, in the arrest, that's when they're trying to get you to fill out the information subpoena, but it's really horrible. So definitely don't ignore any paperwork that you get. As of November 2022, property liens for medical debt cannot be enforced against the debtor's primary residence. So that's really good news. And a debtor's wages cannot be garnished for medical debt. So that's also really good. So if you're working and you're making over the level that's allowed to be garnished, your wages cannot be garnished for medical debt. So that is really, really good news. But your account can still be frozen. We'll get to that in a second. So remember, this also does not apply to credit cards used to pay for medical debt, which I went over. You're using a credit card to pay for medical debt that is now credit card debt, not medical debt. So you can still have your bank account frozen if you have a judgment and it's medical debt. The first $3,840 in your account is protected money. And it's exempt from the lien. But as soon as it goes over that amount, if the plaintiff's attorneys have notified the bank to freeze your account, once it goes over that amount, then your bank account will be frozen. Now, what that means is that the first $3,840 you are allowed to access, but you actually have to go to the bank to access that. You can't use your debit card, you can't write checks, you have to go to the bank and take out that money. And anything over that amount is frozen. It's not going to be taken right away. They will send you an exemption claim form. If you do have things like Social Security benefits in there, or public assistance, or veterans benefits, those amounts are all exempt. If it goes over that amount, let's say you have $5,000 in Social Security benefits, that is all protected money. Now, sometimes people don't realize that it's protected, or the banks don't realize that it's all protected money. So as soon as you find out that it's frozen and you have protected monies in there, contact the bank right away and tell them that money is protected. A lot of times they'll say, okay, fill out the exempt claim form. So then you have to send it to the attorney. Typically, you have to send them all kinds of bank statements showing that all of the money is protected. So just keep that in mind. It's always good to, if you know that all of your money in your bank account is protected, just tell the bank, I get Social Security, but please make a note on that. So that way they don't just freeze it right away. Because if the bank knows that everything in there is from disability, they typically won't freeze it. But just keep that in mind. I have also seen banks that will freeze the account and they just freeze the entire account, which they're not supposed to do. So if that does happen, if they're freezing it improperly, then you can always make a complaint with the Department of Financial Services if they're not unfreezing that protected portion, the $3,840. And then just as a note, if you do have a judgment from the state, like I said, the state sues on Stony Brook Hospital debts, they typically don't freeze your bank account, but they will go after your New York State tax refunds. So if at the end of the year, you're expecting $1,000 tax refund, but you have a judgment with the state's going to take that tax refund. So just keep that in mind. Okay, so some debt relief options if there's no other way to get out of this debt. Of course, there's Chapter 7 bankruptcy, which is a straight bankruptcy. You can't have a certain amount of assets for that. We do offer that for eligible clients here through our pro bono through our Suffolk County pro bono project and our volunteer lawyers project. We do offer bankruptcy, Chapter 7s. And then, of course, there's also a Chapter 13, which is typically used when people have too many assets. So, for example, typically that's when people have a house, and so they have to do a Chapter 13. And that's where the debt is spread over 5 years, and you pay back the debt over a 5-year plan. There's also financial counseling available here on Long Island through the Community Housing Innovations and the Community Development Long Island Financial Counseling Workshops that they do have some workshops there that may be helpful. And then some other medical debt resources for everybody. I just listed here different agencies you can make complaints with if you're having problems, like the Department of Financial Services, the Attorney General, how to apply for New York State health insurance. And then, of course, if you are or a client is having problems with medical debt and you're eligible, well, you don't know if you're eligible or not, but you can call us to see if you're eligible. We have our Consumer Debt Defense Project in both Nassau and Suffolk County, which handles medical debt lawsuits. We have our Public Benefits Unit, which helps out with Medicaid denials. We have our ICANN unit, which helps Medicaid recipients in need of solving problems with their managed care plan. And in Nassau County, we have our Senior Citizen Law Program, which helps Nassau County residents with health care questions. So we have lots of different units that can help out potentially with medical debt lawsuits or even advice and counsel, even if it's not medical debt, but ensuring that you don't go into medical debt, making sure you're planning your health care properly. Okay. Any questions? I talked a lot and I have a lot of information. So if you have any questions, let me know. You can put it in the chat or you can just unmute yourself and ask the question. Okay, so if you do have any questions, you don't want to ask it here, feel free to email me. Everyone should have my email since I emailed you this morning. We do have some upcoming presentations. We have our legal resource fair, which is at the Brentwood Library on October 22nd from 5 to 8 p.m. We have our next presentation is Understanding the 17A Guardianship Option for Parents on October 29th, 1 to 2 p.m. And then next we have Knowledge is Power, Legal Steps After Domestic Violence Incident on October 30th from 1 to 2 p.m. We'll send you the links for those. Also, they are on our website. And then it looks like Maria has a question.
Hey, Sharon, I think the website for CDC Long Island is CDCLI. I'm just looking it up right now.
CDC. Oh. Huh.
Yeah, you missed a C.
I don't think so, because you know what? They changed their name recently.
Oh.
It's not CDC Long Island anymore. It's
Oh, okay.
Development Long Island. So that's
How do you like that? Okay.
Yep.
Everybody changing their name. Okay.
Yep, they changed their name. They didn't want to be confused with the federal government agency, CDC.
Gotcha. Okay. Thank you for the heads up.
You're welcome. Okay, anybody else? Any other questions? Okay, awesome. Well, thanks so much for joining us. We have a survey when you exit the presentation, and I hope to see you all again another time. Bye.